I'm dealing with ground 2, whose Article 8 rights are we dealing with? I gave you the summary submissions before the short adjournment. I wanted to turn directly, if I may, to Article 1 and what the case law tells us about the relevant concept within Article 1, which is within the jurisdiction. If respondents or persons abroad are to be treated as themselves having Article 8 rights, they need, under the Convention scheme, to be, quote, within the United Kingdom's jurisdiction for the purposes of Article 1 of the Convention, which, as you're well aware, is the one that enjoins states to secure the relevant substantive.
Can we look at it? Can we look at it?
My lord. It's tab 64, sorry. Page 1747.
So you say it's obvious they're not within our jurisdiction.
I do. That's the essential submission. I'm going to take you to some case law. I'm going to take you to some cases, 3 cases in particular, that we respectfully submit, tell you about the nature and the limits of that concept within the jurisdiction. So the 3 cases I'm going to take you to are Al-Skaney and the United Kingdom, Khan and the United Kingdom, it's another Khan, not the Khan we've already looked at, and MN for Nanny and Belgium. And the core propositions, if I can do it in 4 short propositions from those cases, are 1, Article 1 jurisdiction is primarily territorial. 2.
Sorry, you've just got to take it a bit more slowly. Article
1 jurisdiction,
yes,
is primarily territorial.
Yep.
Yeah, so in the territory. 2, extraterritorial jurisdiction is exceptional and needs to be justified usually by reference to the exercise of state control and authority over an individual or an area. No exception has been recognised in relation to Article 8 ECHR. In other words, you don't need to show that you're within the jurisdiction just because family life's involved. And 4, there is no justification for any such exception. The basis for the positive obligation, if it exists on the state to permit entry, is simple and orthodox. Article 8 rights are enjoyed by the family members within the state territory, as was expressly recognised by the Grand Chamber in MN and Belgium.
Sorry, were there 4 propositions, did you say?
That was 4. I may have not missed it.
The
3 was no such exception has been recognised in relation to Article 8.
Oh, right.
I'm so sorry. Does that make sense? And
yeah,
4,
no, I just had that as a subclause of your 2.
Yes,
Sorry.
well, could be.
So did I.
I'm sorry. So those are the 4. Al-Skaney first, if I may, Grand Chamber, 2011, behind tab 50. Starting at 1228. This was all about the conflict in Iraq and military operations abroad and all of that.
Gave rise to the Barnamusa inquiry.
My lord, it did, as you will recall, and various, quite a lot of related litigation. With a series of claims being made and fought out in the English courts around that conflict. The reason I wanted to go there was because they deal with the general principles relevant to Article 1 jurisdiction. And they do so starting at paragraph 130 on page 1285. See the title above that, the Court's Assessment, General Principles Relevant to Jurisdiction. It sets out Article 1. And then you'll see above 131 the title. Can I invite you to read 131, establishing the basic rule that a state's jurisdictional competence under Article 1 is primarily territorial.
Yep.
Acts of states performed or producing effects outside of their territories will constitute an exercise of jurisdiction only in exceptional circumstances or exceptional cases. And then at 132, considering what those might be, so the starting point, we say, is that the sponsor on UK territory has a right under, or has rights under Article 8. Individuals outside the territory do not, unless there are exceptional circumstances which require and justify a finding that the state is in effect exercising extraterritorial jurisdiction. But we also note paragraph 137, and we do so because, as you may or may not recall, there was, Alscania had been in the House of Lords in this jurisdiction before it went to Strasbourg, and there'd been quite a debate around whether or not Article 1 could be divided. In other words, if you were within the jurisdiction, did it follow that the state had to provide you with all of the rights that the Convention guaranteed? And you could see why that argument was of some interest, at least to the government, because it led to the submission that said, well, if we're in Iraq, we can't guarantee the right to free elections or to all these other things that the Convention might provide for. But they concluded in Alscania, as a development of the case law, that the rights could be divided and tailored, as they put it in 137. But it is perhaps worth noting the extent to which that principle has to be stretched in this case, because the rights that are asserted have to be extremely divided and tailored, if I can put it that way. It's that the family members abroad only get a right under Article 8, and within that it's only family life that applies on their conception of it if the person is outside, and within that it's only a right which obliges states to grant entry. There's no suggestion that the UK is responsible in any other way for securing family life in the place abroad. So it would require a pretty extreme conception of it to bring it within the dividing and tailoring point. But the court, the reason for going to Alscania in part is because the court more generally described the two main situations in which extraterritorial jurisdiction under Article 1 of the ECHR will be made out. And it did so at 133, if we just go back to that, to 137 to start off with. That is in particular where state agents are exercising control and authority over an individual in the territory. And they give examples of that principle. It's called state agent authority and control. But that's the first basic idea. So, for example, if a person is held in custody by UK forces abroad, exercising state agent authority and control. That's 133 to 137, setting out the nature of, and giving examples of the nature of that exception. The point being that none of them is remotely applicable here, subject to a refusal of entry clearance, as it were, but I'll come to that because that was the stuff of MN and Belgium. But 133 to 137 deals with that basic situation, and the other one, which again doesn't need to control us, to bother us, is where the state has taken effective control of the area, as it's called, ECA, or effective control of the territory. That's dealt with in 138 to 140 of this judgment. And so again, if you're in that situation where the whole territory, as it were, is controlled, then it follows from that that the people within the territory are within the jurisdiction of the state, and if that is the conclusion, you can't divide and tailor in that area. You've got to provide everything. So that is the Grand Chamber starting point, the first attempt to collate all the relevant principles in one place. I say the first attempt, the main attempt in recent times to do so in the Grand Chamber. So that's Alskany. I want you to go to Khan and the United Kingdom behind the next tab, tab 52, page 1368. The facts are summarised as you see on the first page. I can just invite you to cast an eye down that, perhaps to the end of paragraph 7. So paragraphs 3 to 7 will give you the flavour of the facts. So you'll see in summary that he's out of the jurisdiction. So he's a Pakistani national living in Pakistan. He then comes to the UK as a student on a student visa in 2006. He's arrested 3 years later on suspicion of conspiracy to carry out serious terrorist attacks in the north of England. He voluntarily leaves the United Kingdom having been served with a notice of intention to deport. And when he's left, the leave to remain is then cancelled on national security grounds, and he appeals that decision from out of the jurisdiction. He appeals it to SIAC and the Court of Appeal before applying to Strasbourg. That's the basic factual position. And the position in the court when they came to analyse it, if I pick it up at paragraph 24, dealing there with articles 2 and 3 in particular, but 5 and 6 as well. And you'll see the first conclusion of the court in the final sentence of para 24 at the bottom of page 1372, which is that there's nothing in this court's subsequent case law that's subsequent to Bankovic, about bombing the television station in Belgrade, or in the applicant's submissions, to cast doubt on the approach that SIAC and the Court of Appeal took. And if you wanted to see the approach that SIAC took, you go back to paragraph 13. And what is there decided by SIAC, relying in particular on Bankovic, as you see in paragraph 13, top of page 1370. Do you see the paragraph 40, the first bit of the quote within paragraph 13? Does my lord and my lady have that?
Yeah.
Can I just invite you to read paragraph 40 within the quote? No jurisdiction over Pakistan, physically present in Pakistan, none of the exceptions apply. That was agreed to or agreed with by the Court of Appeal. See paragraph 15 of this judgment over on page 1371. Finally, I'm looking at the final sub-paragraph within paragraph 15 on the first whole bunch on 1371. Finally, SIAC was plainly correct. And then in terms of the recitation of the principles, go back to the European Court of Human Rights' judgment, if you would, paragraph 25, where the court refers to the primarily territorial principle, 2 principal exceptions recognised, state agent authority and control. You saw these from Alskany. Effective control of an area, neither applies.
Yeah.
And so they conclude that you can't bring an Article 3 complaint. Even though the allegation there was that the withdrawal of the leave to remain, keeping the individual out of the United Kingdom, had exposed him to ill treatment or Article 3 type ill treatment at the hands of the Pakistani authorities. That was the allegation that based the Article 3 claim. No Article 3 claim on Article 1 grounds, not within the jurisdiction. And then you will see paragraph 27, where they deal with Article 8. The support in the court's case law for the proposition that contracting states' obligations under 8 may, in certain circumstances, require family members to be reunified with their relatives living in that contracting state. However, that positive obligation, back to my lady's point, that positive obligation rests in large part on the fact that one of the family members / applicants is already in the contracting state and is being prevented from enjoying his or her family life with their relative because that relative has been denied entry to the contracting state. See Abdulaziz. And then they say the transposition of that limited Article 8 obligation to Article 3 would in effect create an unlimited obligation on contracting states to allow entry to an individual who might be at real risk of ill treatment contrary to Article 3, regardless of where in the world that individual might find himself. The same is true for a similar risk of detention and trial contrary to Articles 5 and 6. So they've shut the door on Article 3 on Article 1 within the jurisdiction grounds. They're not going to allow Article 8 to be allowed to reintroduce, it's my back door, front door analogy. They're not going to allow Article 8 to drag in Article 3 complaints, which they've shut the front door to using Article 1. And as importantly, the first half of paragraph 27, they explain the Article 8 position on the basis that the person holding the rights is not the person abroad, but is the person who sits and is in, physically in, therefore the territorial principle applies, is in the United Kingdom, or is in the contracting state. So there's no reference there to the person, when you're considering extraterritorial effect of Article 8, there's no reference to the person abroad having a right themselves. If that was their conception, you'd expect to see that part of the explanation. On the contrary, the basis for the positive obligation is the fact that there are family members in the territory of the contracting state, and it's their family life which is being interfered with. That's entirely orthodox and is consistent, we submit, with the Grand Chamber approach in Alskani, which they've cited earlier.
Can I just ask you, in line 4 of paragraph 27, it says the positive obligation rests in large part. What's the other part on which it rests?
Well, my lord, we puzzled over that. I'm not sure they explain that.
Not that I've seen.
No, and it looks from the logic as though that isn't essential to it, as it were. I mean, the reasoning is these cases are explicable because the person is in the contracting state. I agree it's a little puzzling, but...
And the need for the person in the territory of the contracting state is sometimes referred to in some of the cases as the jurisdictional peg, I think.
The jurisdictional peg, exactly. Exactly, but I'm not sure one reads in large part, and so there's a lot of penumbra, as it were, which sits, but there's no explanation in this judgment for that. There's a direct answer to my lord's question. Then MN and Belgium, I was going to go to next, tab 57, starting at 1544. I had the great privilege of being led by Geoffrey Cox, who was then the Attorney General, intervening on behalf of the United Kingdom in a Belgian case, which had caused not a little consternation amongst the contracting states, because it essentially involved the proposition that if you could get yourself to an embassy of a contracting state, wherever in the world it might be, you were within the jurisdiction because you were in the embassy. So that was causing a bit of furor, and or if you could make an application in that way. So lots of states intervened, as you can see from 1545 and 1546, including the United Kingdom. If you go to paragraph 1 of the judgment, you will see that it's really 1, 9 and 10. The applicants were a Syrian married couple and their two minor children. They travelled to a Belgian embassy in Beirut to submit a visa application for themselves and their two children, paragraph 9. They did so for the purpose of travelling to Belgium, but with the intention of then lodging an asylum claim once they were on Belgian territory, in the light of what was, on any view, an extremely serious humanitarian situation in Syria. So ghastly conditions, armed conflict, very similar, no doubt, at least in essentials, with the position in Gaza. The visa applications were refused. They went through the domestic courts in Belgium, and they then brought a claim under Article 3 and Article 6 in Strasbourg. And as I've indicated, the UK, concerned about the ramifications itself, intervened along with a lot of other states. But you see the nature of the claim that is made if you go forward in the judgment to 74 and 75 on page 1559. So 74 and 75 on 1559, just to cast an eye down that, you can see the nature of the complaints. And so, unsurprisingly, the first issue that's taken is, are they within the jurisdiction? And you see the Article 1 of the Convention being recited at paragraph 78, in the terms that you're now familiar with. The parties' submissions on jurisdiction then follow. And you'll see how the claim was put by the applicants at paragraph 83 on page 1561. So I invite you just to cast an eye down that. So they're effectively arguing that the Belgian diplomatic and consular agents in the embassy in Beirut were exercising state agent control and therefore engage the extraterritorial Article 1 jurisdiction. The reasoning of the court is at paragraphs 96 and following, page 1565. And just to pick it up, they're citing all the usual cases, Al-Skani and Bankovich, as you'll see. Pick it up at 98, emphasises the primarily territorial nature of Article 1 jurisdiction in 98 and gives further support for that and further emphasis to that in the paragraphs that follow. 99 does so by reference to the Vienna Convention on the Law of Treaties, and 100 does so by reference to the Travo. And then going forward in their reasoning to (108), just to put it in its context, paragraph 108, you'll see that they distinguish various cases in which there has been held to be extraterritorial jurisdiction, including the one of the set of circumstances where there are specific circumstances of a procedural nature, as you see from 107. The Turkish case cited, and Markovic and others in Italy, which again was about the bombing of the television station in Belgrade, I think. and then you'll see at 108, in contrast, and then they cite Khan with approval. And Khan is the case we've just looked at. And then you'll see what is said importantly in 109. By way of comparison, the court emphasised the above-cited cases to be distinguished from those in which the facts contained an international element which did not involve extraterritoriality for the purposes of Article 1 of the Convention. This was a situation with regard to cases under Article 8 concerning decisions taken with regard to individuals, irrespective of whether they were nationals, who were outside the territory of the respondent state, but in which the question of the state's jurisdiction had not arisen, given that a jurisdictional link resulted from a pre-existing family or private life that the state had a duty to protect. And it's that which provided the Article 1 protection, or the trigger the secure obligation in Article 1. And we submit that's a reference, as it was in Khan, to the Article 8 rights of the family members on the territory. That's what creates the duty to protect. And it matters not because it cannot be a reference to the rights of individuals outside the territory, because that would be to create, as it were, an extraterritorial exception. So that's the explanation of it in MN and Belgium. And we submit that those three authorities together provide strong support for the proposition that you do focus in the Article 8 context, and the rights holder in the context of Article 8 is the person who is within the jurisdiction. There's no extraterritorial exercise of jurisdiction that brings in, as it were, family members outside. I'll come back to the significance of that in due course, but that's the conception in the case law.
And if you go back, for example, to Billy Betts, which is often relied on, everyone was in the United Kingdom.
They were. I'm going to come to the domestic cases right now, but my lady is right. That was a case about where every single family member was within the jurisdiction, and you were having an argument about what that particular provision under the Immigration Act meant. But I wanted to respond a bit to the way in which the respondents put their case, the other side put their case on the ECHR authorities. They say that the case law demonstrates that individuals outside the territory in reunification cases themselves have Article 8 rights, and they point to the fact that in those cases the applicants in the claim sometimes include individuals abroad, in addition to the individuals within the state's territory, and sometimes don't distinguish between the applicants who are within and without the territory, when referring to the various rights and interests under Article 8 of the ECHR. And we've got two main responses to that, if I can summarise it without unduly taking up time on it. First, in none of the cases that are relied on by my learned friend is a jurisdictional objection raised in relation to the applicants abroad, simply not argued or considered, and no reasons are then provided as to why the applicants abroad might be conceived to have Article 8 rights. In any event, the cases that are relied upon need to be read subject to Khan, which I've taken you to, and MN, which I've taken you to, Grand Chamber, where the court did consider the jurisdictional basis for an Article 8 reunification claim and said, in summary, and partly the point my Lord Justice Dingemans put to me about what that little phrase meant in Khan, query, but essentially said it rested with the individuals in the territory. And one can point to a variety of cases. I'm not going to invite you to take them up, but just to take as an example, Nessa and Finland, tab 45, page 1158. I'm just going to give you the submission if I may. Miss Nessa was in Finland, and she was applying on behalf of a daughter and granddaughter outside of Finland, and they were collectively treated as the applicants. The claim was that refusal to permit entry breached Articles 3 and Article 8. But in that case, there was no analysis of jurisdiction in relation to the applicants outside the territory. We now know it's absolutely clear from both MN and Belgian Grand Chamber and Khan that you cannot seek entry on Article 3 grounds from outside the territory. So that is clear. Article 8 is addressed in the judgment, but again, no jurisdictional objection raised or argued. And we respectfully submit that that cannot provide authority, as it were, against, for example, Khan and MN. And the same point applies in relation to each of the other respondents' cases, or the cases that the respondent relies upon. Point simply not taken, not argued, not ruled on. It applies to the Sen case, authorities tab 47, to the Long case, tab 51, to the El Gatek case, tab 53, to the BF case, tab 59, all of which are referred to in the respondent skeleton. The jurisdiction point in relation to the applicants outside the state's territory is simply not argued or ruled on. There are then a set of child abduction cases that are relied on by my learned friend, in his skeleton argument, for the proposition, it appears, that parents abroad are treated as falling within a state's Article 1 jurisdiction for the purposes of Article 8. But those cases, of course, are in a completely different context. It isn't family reunification in that sense in those cases, pure and simple.
Are they all Hague Convention cases?
And they were mostly Hague Convention cases. They say nothing in any event about how Article 1/8 works in entry or reunification cases, on which we have the guidance of M.N. and Khan. And they can in any event be explained as concerning the territorial jurisdiction of the state. So, for example, Ignacolo Zenide, tab 41, page 1014, that was an application by the mother in Romania against Romania in relation to the abduction of her children to the United States. One sees from paragraphs 11 to 9. And then at paragraphs 89 onwards, the complaint there was that the Romanian authorities had not, brackets, within their jurisdiction, where the mother was as well, by the way, acted quickly or effectively enough to enforce the decisions of the Romanian courts. In other words, to prevent the children being abducted to the United States. And the same explanation applies in relation to Sylvester and Austria, tab 44, page 1132. There, the applicant was an American citizen and his daughter. The mother, an Austrian citizen, took the daughter to Austria without the father's consent. The first applicant, that is the father, obtained an order in Austria for the daughter's return and sought to enforce it in Austria. That order was ultimately set aside by the Austrian Supreme Court, and the father and daughter then complained that the review and the setting aside of the enforcement order was itself a breach of Article 8. So that's a case about the acts of the Austrian authorities in Austria in relation to a child in Austria and a father who had participated in Austrian proceedings and plainly had rights in those proceedings. It's a bit like Markovic. Do you remember the reference to Markovic? That was about Italian proceedings. It's the same thing. And by the way, note also in Sylvester and Austria, paragraph 50, the existence of the right and the interference with it was conceded. So there was no jurisdictional consideration of the father's rights in any event. There are other cases in Strasbourg, again, where the jurisdictional objection is raised and not determined. I don't need to trouble you with those, but for the sake of completeness, there are two cases in which a jurisdictional objection was taken by the Netherlands, but in neither of them was the point decided. And both of them arose before, I should add, Al-Skani, or Khan, or MN. The first one is called Haydauri and the Netherlands. Can I just invite you to take that up? That's at tab 48. And it starts at page 1197. And if you just see the facts from the opening paragraph, at the bottom of 1197, the mother and one of her children were in the Netherlands, the other three children were in Pakistan, all of them were the applicants, as you see, and then at 1206 in the bundle to 7, you will see that the Dutch government raises a jurisdictional objection to the application of the three children. And at 1208, second paragraph, you'll see that the court didn't determine the objection on the basis that as regards the family life at issue in the present case, the existence of which is not in dispute, no distinction can be drawn between the two applicants living in the Netherlands and the three others currently residing in Pakistan. and you don't get any analysis of jurisdiction which might support a suggestion that the other applicants do in fact or are properly to be regarded as having Article 8 rights themselves. Then in the next tab, tab 49, this is the Tricabo, Teckley and others in the Netherlands, 1211. And in this case, doesn't again provide any support for my learned friend's case. Paragraph 8 on page 1213, all but one of the applicants lived in Amsterdam, one was in Eritrea. Paragraph 26, you'll see the same jurisdictional objection is made by the Dutch government, which had evidently had the bit between its teeth by this point. Same jurisdictional objection raised. At this time, the government, the European Court does not decide the issue on the basis that the government was stopped from raising the objection because of a timing point. They hadn't raised it in time. See paragraph 32. 30 to 32, really. So again, there's no analysis of the point in consequence. So we submit on the Strasbourg Authority. There is clear case law explaining how the position works in family reunification cases in relation to Article 8. The basic position is explained that the jurisdiction in question, the person within the jurisdiction of the state is the person who is in the territory of the state. There's no suggestion that the position is otherwise. That is the explanation of the cases in Caen, it's the explanation of the cases in the Grand Chamber case of MN, and that is consistent with the principles set out in the limited, exceptional circumstances in which extraterritorial jurisdiction is found in Al-Skani.
Can I just ask you on 1208 and Hadari, why couldn't the court draw a distinction between the applicants in the Netherlands and the three others in Pakistan? I mean, doesn't that support the proposition that you just treat, once you're in the family unit, you're in the family unit? It's a slightly odd paragraph because they go on to find it isn't necessary to determine whether they could be regarded as being within the jurisdiction. So they don't go there, and I think it's because they had enough in the present case, as they put it, but they had enough because the people concerned, or some of the people concerned, were in the jurisdiction. So they didn't need to consider. They're not saying we don't need to determine it because we can conclude that the people outside have rights. They don't need to determine it because on the facts, in the present case, as they say, it wasn't going to make any difference one way or t'other. That's as I read it. Because otherwise they wouldn't be saying we don't need to determine the issue of jurisdiction. Thank you.
So we've got the reasoned explanation for the case law in cases I've taken you to in Strasbourg, and nothing in the cases that my learned friend relies upon actually takes the matter any further. They certainly are not authority, because they're all explicable on the basis I've indicated, or they don't touch the point. There's nothing in the authorities to gainsay that explanation, namely the right holder is the person who is within the jurisdiction in the ordinary and orthodox territorial sense. And I emphasise that because it's the European Convention Authority that provides the guide, a bit like it was in relation to Ground 1. That's your yardstick. And even if it can be said that there's a little more room for doubt about precisely how the position works in Strasbourg in this context of Ground 2, you've still got, at the very least, we say the position is clear because of the Grand Chamber clarification, particularly in MN, but even if not, you've still got to be fully competent under AB before one jumps to the proposition that people outside the jurisdiction, over whom no state agent authority and control is being exercised, suddenly acquire Article 8 rights themselves, simply because they have a family member in the United Kingdom. We submit that is an overreach not supported by the authorities. Can I turn then to the domestic authorities relied on by the respondents? And as we understand the respondents' argument, that's the argument on the other side, the argument goes as follows. Once one family member is in the jurisdiction, their right to respect for family life necessarily obliges the contracting state also to accept jurisdiction and responsibility for the right to family life of every other family member, including those abroad. And that is said to stem from the unitary nature, as it was, of family life as considered in Beku Betts. We rely upon comments of the House of Lords in AS Somalia and the Court of Appeal in Abbas. The Secretary of State's submission is that that would represent a very material, and we say surprising, extension of extraterritorial jurisdiction under Article 1. We submit that neither Beku Betts nor AS Somalia support that position, that the comments in Abbas were obiter, and that the decision in Hassan, which is relevant, was wrong. If that truly were the position, i.e. the position as the respondents contended to be, it is surprising, to say the least, that it is not set out clearly in the Convention case law and the Convention itself, it might be thought. Can I turn then to Beku Betts, first of all, which is a House of Lords decision of 2008. Behind tab 6, we've looked at it already, tab 6 in the bundle starting at page 93. And the first and critical point to bear in mind is the point that my lady has already drawn to our attention, which is, as one sees from the head note at page 93, just cast an eye down that it is a case in which the claimant and the rest of his family are in the UK. They fled there from Sierra Leone. So the claimant and each of his family members had Article 8 rights because they were on UK territory. Perhaps the second important thing to note from that head note is what the issue was in that case. The issue was as to the proper interpretation of Section 65 of the Immigration and Asylum Act 1999, what is now Section 82 of the 2002 Nationality, Immigration and Asylum Act. When someone challenges a refusal to grant, in that case, leave to remain, on human rights grounds under that section, it is only their rights which must be considered, or is it the rights of their family members too? That was the question. That each of the family members had rights was not an issue under Article 8. And that meant that the procedural effect of limiting consideration to the rights of the claimant only is that if other family members' rights are breached, they would need to commence separate proceedings for JR. The question was whether the section on its proper interpretation compelled that outcome. The judgments begin, or the speeches begin, at page 97. I just invite you to note from the concurring judgments of Lords Holmes, Scott and Bingham that the judgment that they agree with is that of Lord Brown and not of Baroness Hale. I'll come back to her concurring judgment in a second. She agrees with Lord Brown as well, so I'll start with him. In Lord Brown's judgment, you can see how the appellant put their position from paragraphs 20 and 21 on page 101. Of course, those submissions are made in the context where every member of the family has rights under Article 8 that they can enforce against the UK. There's no submission that this is how it must also work if some of the family members are abroad and have no rights against the UK. At paragraph 23, you will see that the Secretary of State's case was that the wording of the section was restrictive and allowed consideration only of the rights of the person challenging the immigration decision made in relation to them. Then between 24 and 40, there's quite a long section in which Lord Brown surveys lower domestic cases, which broadly reflected the Secretary of State's interpretation. The key domestic case, AC, and the key Strasbourg case, Cézanne and the Netherlands, which Lord Brown considered, are cases where, again, the entire family unit was in the territory of the relevant contracting state. See paragraph 26 for AC and 38 for Cézanne. So the House of Lords was simply not concerned with whether rights under Article 8 exist extraterritorially for the benefit of family members outside the territory. Lord Brown's conclusions are at 41 to 44, in a short section of the judgment on page 106. And at 41 to 43, he considers the procedural disadvantages of the then present narrow approach in the domestic authorities. And it's evident from 43 that he considers the intention behind then section 65 as being to have created a one-stop shop rather than to necessitate parallel sets of proceedings. So administrative efficiency is at the top of the list in terms of interpretive features. As I emphasise again and again, all of that reasoning is concerned with a situation where each family member has rights and a claim under section 6 of the HRA that needs to be ventilated somewhere. At the end of 43, you'll see he makes an additional point, beginning just below the letter F, once it is recognised that. I've got it to read there at the end of the paragraph. And that's a reference back to paragraph 31, which was a consent order agreed in the AC case, where, as we saw earlier and as is clear from paragraph 26, again, every family member was in the UK. That's why you have to look at the family unit as a whole, and that's why every family member is a victim if the removal is disproportionate, looking at the family unit as a whole. You can well understand how that follows. What's the purpose in considering those claims separately, where each family member has a right which is affected by the immigration decision?
I mean, where does this point go? Because if you're assuming, for the purposes of this point, that family life exists between all the 6 applicants and the sponsor, then it is that so-called unitary family right that the court has to look at for the purposes of the proportionality exercise. So, I mean, of course, you may well be right, and I was putting it to you this morning that you were right in relation to the existence of family rights. Do you look from one side or the other? We won't have that debate again. No. But I'm just wondering where you say it goes, if you're right. Why does it matter?
My lord, I tried to deal with that, and I'm going to come back to it. I tried to deal with that in the overview I gave you just before the short adjournment. The basic submission in answer to my lord's question is...
Well, you said focus, but I mean...
I say focus. I mean, you may say that's too ephemeral, and what's the point of that? But it does make a difference, I submit, if you focus on the idea that the relevant right that is being interfered with is the right of the person within the jurisdiction. The question is whether it's proportionate to do so, or more accurately, whether there is a positive obligation on the state to admit, given the impact and severity of the consequence for that individual.
As I understand it, your proposition is that the concept of unitary family life is only legally relevant when all the members of that family are in the UK within the jurisdiction.
Yes, and for the purpose, particularly in Beku Betts, of the issue of interpretation that
Yeah.
arose in that context, where one can well see that that might make a difference. I am not saying, I should make entirely clear, that you then, as it were, ignore the circumstances of the family members who might be abroad. Those circumstances can be taken into account and are relevant. And see, my Lord's BDI, how is this really in truth significant? But I respectfully submit and maintain the submission that it is significant because you have to focus on the nature of the right that's interfered with, the nature of the right that is actually an issue.
But I mean, the word unitary, which appears
Yeah.
in various places, is not only applicable to cases where all the people are within the jurisdiction. Once you I mean, let's just take a case, not this case, but a case where there are two brothers, one in one jurisdiction, one in another, and for some reason they're very close and they have the necessary dependency, and you're then considering whether the proportionality exercise falls one side of the line or the other, and A in the jurisdiction is totally dependent on B outside the jurisdiction, right? The family life you're considering is that of A being dependent on B, and requires you to look at the circumstances of A and the circumstances of B. I would be inclined, anyway for myself, to say that you probably do start with the focus being on A, who's in the jurisdiction, but at the moment I can't really see why that is likely to make a huge amount of difference. Again,
Well,
it seems
yeah.
to be one of these sort of use of language questions.
My Lord, maybe, and of course I acknowledge it may make more or less difference depending upon the circumstances of the particular case. If we're dealing with a true case of dependency, one can see that the thing might shiver into rather less significance than otherwise. The concern, however, is that if you treat, as it were, everyone as having those rights, then the worry is that you drift very quickly into having regard to circumstances that are related, as it were, simply to the individual concerned in the foreign state, the poor conditions under which they're living, a kind of Article 3 type complaint, which we know is shut away, and we know was absolutely central to the Upper Tribunal's reasoning in this case. So the requisite focus may, my Lord is entirely right, in certain circumstances drift towards nothing in terms of its practical significance. It nevertheless remains important because there are other cases in which it may really be quite significant, if only to exercise.
Surely
Sorry.
have. I mean, I see all that. You can have regard, can you, to any aspects of the circumstances of the members of the family, which affects their family, affects their Article 8 situation, affects the entire family's situation, not the Article 3 rights of the family outside the UK, but from the Article 8 perspective, you still have regard to the whole family.
You can have regard to the whole family, and you can have regard to all of the circumstances. It's an argument which is not extreme in its propositions, as it were. But you can have regard to all of those things. But the risk, as I say, is that unless one is careful, you end up not focusing on the degree and nature of the interference with the person who actually holds the rights.
So apart from this judge, or this Upper Tribunal, saying that the Article 8 rights existed in the family abroad, which you say is wrong, right? I understand that. How does it show, if you're right about this argument, let's assume you're completely right about it, but is all the colouring that we've now achieved, how does it show that the balancing exercise, proportionality exercise undertaken by the Upper Tribunal was wrong?
Well, my Lord, the one-line answer to that, and I'm going to come to address that under ground 3 in particular, but the one-line answer to that is that it shows because the critical features that were relied upon by the Upper Tribunal were pretty much all to do with the awful conditions in which, in particular, the children were living in Gaza. And they were not, as it were, taken back and said to exacerbate the worries that the uncle or brother had in London. They were treated, in effect, as impacts on rights that were held by those children. And that's what I mean about the temptation, because it becomes very, very easy in those circumstances to pay lip service to the fact that the front door is shut in Article 3 terms, but to then drag back in exactly the same features through the door marked Article 8, because you can take into account unitary nature of family life, and that means any impact on any member of the family wherever they may be in the world. What drove this decision, I will submit, when fairly read, are the interests of the children who were sitting in the appalling conditions in Gaza.
Because at best, the relationship for Article 8 purposes between the rights holder in the UK and somebody outside the jurisdiction is the relationship between the sponsor and the brother he hasn't seen for 17 years.
Yeah.
That's the proper focus.
That's
of the
the proper
Article 8
focus.
debate. And the problem with the approach of the Upper Tribunal, as I understand your submission, is that by talking about unitary family rights and all the rest of it, the Upper Tribunal are dragging in legally irrelevant considerations, that is the effect on the members of the family of the brother in Gaza, rather than the relationship that's relevant for Article 8 purposes, namely the relationship between the two brothers.
My lady, yes, and even if one could extend it more broadly into to taking into account broader considerations relating to the children in Gaza, the significance of that would only be on the relatively ephemeral and associative connection that is asserted, but it would only be on the impact on the interference with the brother's rights in the United Kingdom. So he's more worried, as it were, than he would otherwise have been, because they're sitting in ghastly conditions. Instead of which, you have the Upper Tribunal's reasoning absolutely at its heart being driven by the idea that these children had to be got out of those ghastly conditions. And that, as it were, is an analysis which places the rights in their hands and looks at them in a way which is not legally legitimate. And it's a point of some importance, because it's a question of whose rights you're actually focusing on. Yeah. And ordinarily, when you're dealing with interference and proportionality and justification, you say, what's the nature of the interference? Who does it interfere with? And what's the impact on them? Whereas here you've got impact on people who don't hold rights, which is being dragged back in without, as it were, even an attempt to put it back into the box marked brother. Yeah. So that's the concern.
I just ask you one thing in relation to that. I mean, if there is a family life, and obviously your submission is there isn't, but the brother's interest then is therefore the continued existence of the family, how is the tribunal, on your analysis, to take into account of the threats to the family without actually discussing the situation in Gaza?
Well, my lord, as I say, if it's permissible to take into account those considerations at all, as it were, then you take into account the ghastly conditions, you take into account the existence of the threats. But the reason that those are, if at all, legally significant is because of the impact that or those facts might have on the applicant in London. It's tying it back to that all the time. So I say otherwise, it looks like what you're doing is saying they've got rights. It's in effect like they've got rights, they've got Article 8 rights to be removed if the conditions are bad enough. And that, if that isn't bringing Article 3 in through the back door when the front door is shut, difficult to see what is. But that was the thrust of the analysis.
I get all that.
Sorry, that's not a wrong way.
No, I mean, it's helpful. What I would find very helpful is if you could point me to the paragraphs of the Upper Tribunal's judgment, which you say goes the wrong side of your line.
Yes. My lord, can I do that? Because when I get to ground 3, I'm going to do that and pull it all together, if I may. There's going to be a variety, I'm afraid, with respect to them, of complaints about that, or concerns about that judgment. That's going to be one of them. But can I do that in that context?
Yes.
Might make your notes easier to read afterwards, as it Can I go back to Beku Betts, because I wanted to deal with the Baroness.
Yes. You wanted to deal with?
The Baroness.
Yes.
So the Baroness
We've
is
read the Baroness's.
paragraph 4.
She wasn't in the majority.
Yes, exactly. No other lord agreed with that in this case. It's about whether the section allows consideration of everything or requires separate proceedings. That was the issue, as we know. It was insisting on separate proceedings that misses what Lady Harold says is the central point about family life being that the whole is greater than the sum of its parts.
Well, you probably agree with that.
I do. That much is entirely uncontroversial. If you're dealing with the situation which Lady Hale was dealing with in that case, under Article 1.
I mean, it's quite, it's, I shouldn't say that, but anyway, yes, it's nicely phrased, but you say wrong in the previous sentence.
I do, and I wanted to just pick up on the last line, which has had a bit of a run attached to it in later cases perhaps, but just have a look at the last line. We submit that needs to be treated with a little caution. No authority is cited for it. None of the other law lords agree with it. And it might be thought that the wording is a bit unclear anyway as to whose rights Lady Hale was referring to.
Well, in context, she must mean the rights of the spouse, of the rights holder, and or the child of the rights holder.
You'd think so, but
How could it be wider?
quite. That's enough on Beku Betts, I hope. AS Somalia. I'm so sorry, it involves a rather dull trawl of all these authorities, but probably done. AS Somalia, House of Lords again, tab 10, page 171. Can I just invite you to cast an eye down the head note? You'll see as you do so that this is an entry clearance case involving orphan children in Sierra Leone who had formed part of their cousin's family unit there, but after their parents were killed, the cousin then made their way to the United Kingdom and wanted to bring them with her. The issue, still in the head note, was another question of construction, this time with Section 85 of the 2002 Act. The question was whether an immigration judge was entitled to take into account a bad change in circumstances since the refusal of entry when reviewing that refusal, or whether the children needed to make a fresh application for entry clearance. The appellants, who were the orphaned children, argued that a construction which failed to allow a consideration of a change in circumstances was incompatible with Article 8. And that argument was rejected by the House of Lords. So that, I hope, summarises the facts in the head note. If you go into the judgment at paragraph 6, you will see how the argument was put by Mr. Manjit Gill, Queen's Counsel, at page 175, para 6.
Sorry, so they did have to make another application?
Yes.
Yeah. 175, para 6.
175, para 6 for how the argument is put. They were making the argument that it was an incompatibility argument by reference to the positive obligation to reunify the family and the impact of delay upon that. And for that purpose, it was said they could rely on the cousin's Article 8 rights, the cousin being in the UK. Paragraph 6, they don't even identify whose Article 8 rights are engaged. That's because they don't need to. It's open to them to run an argument of construction by reference to the cousin's Article 8 rights and the Article 8 rights of others that might be affected. And Lord Phillips, with whose judgment all the other law lords agree, says nothing at all about the question of whose rights might be affected. So nothing in Lord Phillips. Lord Hope says a little bit more if you look at paragraph 13. see him describing the core of the appellant's arguments just below the letter D within paragraph 13 on page 176. And he records in that paragraph a concession from the appellants that if no member of the appellant's, the applicant's family were already in the UK, then it would be difficult for an incompatibility argument to run. And you'll see what he says, the core of his argument and so on. So there was no suggestion from the appellants that they had Article 8 rights out of the jurisdiction. And then paragraph 16, which I think the respondents rely upon, can I invite you to read that? Points on that passage perhaps. The question is simply whether there might be some cases, or there might in some cases be an Article 8 interest in play when dealing with an entry clearance decision, and the answer is plainly yes. Lord Hope is there quoting from Baroness Hale and Beku Betts, the minority judgment as we know. He's not going beyond what she purported to decide in that case, and for the reasons I've already mentioned, the correct reading of those words is that they don't create extraterritorial Article 8 rights whenever there is an Article 8 right owed to someone in the jurisdiction. Lord Hope is saying no more than and goes no further than the orthodox proposition that one or more family members may be in the jurisdiction and hence entry clearance cases may affect them. Then Lady Hale again, at paragraphs 22 and following, again, I emphasise, none of the other lordships, of their other lordships, agree with her judgment, so it's no part of the majority reasoning again. At 23, you'll see that her judgment is concerned with what she says should have happened at the point that entry clearance was considered. It's not concerned with the issue in the case, which is whether the section, the relevant legislative section, permits a judge subsequently to consider changed circumstances. So as well as being in the minority and unsupported, it was overturned. And within that passage in 26, Baroness Hale says, as you see, that the decision in Beku Betts was that the interests of all family members have to be taken into account when assessing the Article 8 claims of any of them. With respect, that needs to be treated with a bit of caution. Only, we submit, in relation to the rights which other family members in the jurisdiction have. Beku Betts stands for no broader authority than that, no broader proposition than that. So there's nothing we submit in that paragraph which could be taken as authority for the proposition that you have, as it were, created Article 8 rights for children if they are sitting abroad. If it's saying simply, well, you look at family life in the round, that may be so. You look at all the circumstances, but the question is, what do you then do with those circumstances? Who do you focus on?
Well, what she actually says is, the interests of all family members have to be taken into account when assessing the Article 8 claims of any of them, which seems to confuse the Article 8 rights of somebody in the jurisdiction
With the interests of someone outside.
Save that Beku Betts was a case where that could have been the case because they were all in the jurisdiction.
Yeah. That's it on AS Somalia. Can I turn to Abbas?
Actually, just one finishing on what she had to say. It seems as though it all comes down to the fee. You shouldn't require them to pay a second fee if they have to apply for entry clearance again.
Yeah. But again, one can see these concerns as feeding into an issue of interpretation and the practicalities of doing it one way or the other. Abbas, I wanted to go to, if I may, tab 22. Again, if you just look at the head note, if you would, on page 474, important thing to note, perhaps from the head note as you cast an eye down it, is that it was an entry clearance case where the applicant, based in Pakistan, had no established family life or private life in the UK. What he was arguing was that entry clearance would prevent him from developing a private life underlined, in the UK. And the Court of Appeal rejected that argument, saying he couldn't draw support from the family reunification cases to that end. So this is a private life case, not a family life case. The facts are summarised by Lord Justice Burnett, paragraph 5. Visitor visa was refused after entry clearance had previously been refused for use of a false document. Paragraph 15, he considers the case of Singh, the tribunal case, where removal from the UK impacted on a private life established in the UK. And paragraph 16, can I invite you to read, particularly that first sentence which is relied upon against me.
Why was there no dispute about that?
Well, my lord, I'm not entirely sure. It may be because it didn't matter terribly on the facts of the case, but the point that we would make about that first sentence in particular is that this is all being referred to in a case concerning private life, simply for the purpose of contrast.
I thought you told His Lordship this morning that there was no real difference. Are you saying that a private life, I mean, surely you're not saying there's a completely different law applicable to private life?
Well, there may not be in relation to private life, but on the facts of this case, there was no corresponding person in the jurisdiction or anything of that kind. Whereas the context that we're considering is family reunification and degrees of relation within that. But my point about that first sentence is that it's in a case about private life, and it's therefore obiter at the very least. It may not have been disputed in that case, but if that authority, if that proposition is taken at its breadth, it is very much disputed here and is the subject of full argument.
Isn't that just a shorthand way of referring to the entry clearance cases in which there is a rights holder in the UK and somebody outside the UK applies for entry clearance to be reunited with the rights holder in the UK?
My lady, that was going to be my third point. It can be read in entirely that way.
Yeah.
And then it would be consistent. It's only if it's taken at its broadest, which the respondents appear to do, that it's problematic. And if it were to be taken at its broadest, the authority that's cited in support of it is Abdul Aziz. But in Abdul Aziz, tab 37 if you need it, I invite you to turn it up now, the applicants were the wives who were permanently settled in the UK.
Yeah.
Not the husband. There was absolutely nothing.
The point I've just made.
Yeah, it's absolutely nothing in that case to suggest you didn't need the person in the jurisdiction.
No.
But my point is you don't need to disagree with it or get worried about precedent or anything of that kind. It's obiter can be read sensibly as my lady has put to me. And in any event, if taken too broadly, is obviously not supported by the authority which is cited for it. And then one gets to paragraph 19. We don't disagree with the proposition in the first sentence, no equivalence between private life and family life. family cases, you have someone with an Article 8 right in the jurisdiction. You don't have that in the family case. There's no such thing as private life reunification. Same point doesn't apply to family life. That's the essential point for the purposes of this case. And it appears, potentially at least, as though Lord Justice Burnett might have been reading the passage in Khan in the UK as being based on the unitary nature of family life, meaning that interference with the family life of one is interference with the rights of all of those within the ambit of the family whose rights are engaged. But Khan, as we saw, doesn't say anything of the sort.
No.
Khan bases Article 8 reunification cases precisely on the opposite, on the fact that there is someone within the article with an Article 8 right in the jurisdiction. It doesn't say that those out of the jurisdiction have rights, nor as we saw as Zemen in Belgium.
But he does seem to understand Beku Betts as saying that there is a single family life, and you have to look by reference to the family unit as a whole and the impact of removal on each member. That was Lord Brown and Beku Betts.
Well, my lord, the difficulty with that is we've been through Beku Betts.
They were all in the UK.
They were all in the
and
UK.
It was a
every
case
single
about
one of them.
removal, and
Yeah.
this is not a case about removal, and they aren't all in the UK.
Yeah, I mean, it may be that the fudge is between, you know, potentially relevant circumstances in certain cases, and rights, but nothing in Beku Betts can be taken as
So you say this is taking it too far.
it's taking it too far, but you don't need to worry about this binding you as a matter of precedent.
But it's all over, sir.
It's all over because this was a private life case, and they decided the private life case against the applicant. But if and to the extent that he's relying on Beku Betts for that broader proposition that, in effect, the unitary nature of family life equals rights on every member of the family, wherever in the world they may be, that is certainly not what Beku Betts decided, as we've seen. And again, it may be that as well to show you finally because there has been some confusion about how far all this goes. These are difficult cases, no doubt, to trace your path through. If you go to Hassan, which is in Authorities tab 30. Yes, sorry. Yes, of course. My lord, sorry. Could I ask you just to rise for a minute or two?
We will rise for a minute or two. Can we be told when you
Yes.
rise?
Good. That's not very supportive. I missed it. So why isn't that like the answer to all this? Sorry, no. Thank you. Yeah, if you stop at 3.
Rise equal.
Lords, my ladies, sorry, I jumped from Abbas rather too quickly. There's one other passage I wanted to take you to. Can you go back to tab 22, page 482?
Sorry, 22.
Tab 22, page 482. So you'll see at paragraph 22 by the letter G that the court allows the appeal. But then you see 23. I turn briefly to the question of the jurisdiction of the ECHR. So he's turning to Article 1. Can I just invite you to read 23, 24 and 25?
No other argument to suggest that the applicant and his family are within the jurisdiction. Yes. It's a slightly mercurial paragraph because it's sort of, it's not quite clear how it relates to what he said before.
No, I entirely accept that, but if I'm allowed to put it in this way, his jurisdictional heart is in the right place.
Yes, okay.
Not sure,
I'm sure.
not sure
He became the Lord Chief Justice of Wales. Of course it was.
extremely august, so it's not entirely unsurprising as it should be. But the point essentially is it's that reliance on the person in the jurisdiction as creating the requisite jurisdictional link, as it were, and then reliance upon no effects under Bankovic and primarily territorial under Palestinians. I was going to go to Hassan, tab 30. It's the decision of the Upper Tribunal, so it's obviously not binding on the court, but worth looking at it briefly perhaps because it shows what we say was the previously correct approach followed in the case of KF Syria, which then led to a bit of confusion following some of the comments in Abbas. And you'll see the facts at paragraph 2.
What page number are we on?
I'm so sorry, my lord. 618 it starts.
Thank you.
Behind tab 30. I was going to paragraph 2 on page 619 for the facts. Members of one family that fled from Syria to Jordan, one of them the sponsor, then fled to the UK in 2014.
It's similar facts.
Similar.
Okay.
There are 10 appellants, paragraph 3 as you see. And then paragraph 20 quotes Abbas.
Yeah.
And he says that they're technically obiter. But accepts they're an accurate statement of the law. Problematic thing, we respectfully submit. But you see the impact of Abbas.
So where does he say technically obiter? I can't see that.
22.
22, yeah, thank you.
Oh, I see.
I've made my submissions on Abbas, so I'm not going to go back to it. But you'll see, if I may say so, part of the real reason for going for this is if you look at KF Syria 23, we respectfully submit that correctly summarised the law, and the misreading of Abbas appears to have led to some confusion. And we say that view of the law in the quote in paragraph 23 is supported by Khan and the UK and in Belgium and so on.
Then in 24, he says you have to focus on the family unit's rights as a whole, and all of them.
Yes. And the rights of all of those concerned, which it might be thought is rather question begging, because the question is whose rights are you dealing with, who have got rights, and to that you must apply the jurisdictional analysis under the case law. So can I very briefly summarise on ground 2 where we end up?
As you've taken us to it,
Yeah.
so I understand it. Paragraph 24, do you say 24 is right?
No, 24 is not right.
Right.
We say that the quotation within paragraph 23 is the correct approach.
In AS Syria, KF Syria.
Yeah.
And KF Syria,
Was a decision by whom?
Upper Tribunal.
so the Upper Tribunal got it right in KF Syria, but wrong in this one.
But wrong in this one, exactly, that's a submission. And they've got it wrong in this one because they appear to have misunderstood what was being done in Abbas. If you want it in the raw, it's tab 23, KFC, or else I'm going to take you to it.
And Abbas is obiter.
Abbas is obiter and explicable on the basis that we discussed.
Messy.
It is messy, I'm afraid. It is messy, and what seems to happen is that you get a kind of domestic authority putting a particular read or arguably doing so, and then that's taken on by an upper tribunal or other courts and treated as established truth.
Well, I might have some sympathy, having seen all this, for the tribunals below.
Yes, well, I mean, I'm not going to disagree with that.
Before we leave that 24, can I just ask you, because this tribunal looks at it as a principle, we don't accept it's correct to look at KF Syria. To do so risks a failure to focus on the family unit as a whole and the rights of all those concerned. So you accept you've got to look at the family unit as a whole, but not the rights of all concerned, because they don't have any rights.
Yes, you can look at the circumstances of everyone, and the question is, what is the legal significance? Why are you doing that? By reference to whose rights are you doing that? That's why it's important to go back onto that focus point, but that's how we put it.
Thank you.
I mean, that's a distinction that's jolly difficult to apply. I mean, you look at everybody's circumstances, but through the eyes of the rights of the sponsor, or the UK.
Yes, that's what you do.
I mean, that's why I keep on asking why it matters, because, and why I still want to go to the paragraphs in the UT's decision that are said to be wrong, flat wrong, which I think you have suggested they were, to see what they actually looked at, to see whether your distinction is competent to reach that conclusion.
Yeah, oh, I get that. Would it be helpful to summarise the conclusions on ground 2? I started with them and it made it a bit repetitious, but...
I mean, is it repetitious of what you said at the beginning?
Well, it probably would be, so perhaps I don't need to trouble you with this.
As long as we get 4.
As long as...
We get 4 rather than 3.
Yes.
Well, we got them, didn't we? We had
We
4.
did, yeah.
Yes, Article 8 rights only enjoyed by those within the UK's A1 jurisdiction. The fact that one family member may be in the UK does not confer A8 rights on every family member outside the UK's territory. None of the Strasbourg authorities or domestic authorities have grappled with or endorsed that proposition or support it. Khan and MN Belgium make clear that the jurisdictional basis for an Article 8 claim to family reunification is the right of the sponsor or family member in the territory. It's right to focus on the interference with those rights when it gets to proportionality. That may or not precludes consideration of the circumstances of
other members of the broader family unit, but it frames the relevance of those circumstances. Ultimately, you're justifying interference from what's casted in that way, recognising
Right.
it's a positive right, with the sponsor's rights.
Those are quite different submissions to the 4 you gave us at the beginning. So I'd either like them done slowly so I can write them down, or I'd like them in writing.
All right. Well, let me give them to you now. It won't take long. Article 8 rights only enjoyed.
Hang on, let's get to the right place. This is 8 conclusions. Yeah, 1.
Article 8 rights only enjoyed by those within the United Kingdom's Article 1 jurisdiction.
Yeah.
2. The fact that one family member may be in the UK does not confer A8 rights on every family member of theirs outside the UK's territory.
And by family members there, you mean people who have a right, a family right within Article 8.
Yeah.
Yes. Yes.
You've got to cross that bridge to get
We've got to cross bridge number 1. Yeah. 3.
3. None of the Strasbourg or domestic authorities, correctly read, so conclude. In particular, Khan and MN Belgium make clear that the jurisdictional basis for an Article 8 claim to family reunification is the rights of the sponsor or family member in the territory. I think that was 3, wasn't it?
Yep.
Was, yeah.
4, sorry, it is right to focus on the interference with those rights when the analysis moves to proportionality, because proportionality asks about the extent and impact of the interference with the right holders' interests.
Yes.
5, that does not preclude consideration of the circumstances of other family members, as it frames the relevance of those circumstances. Ultimately, what you are justifying is interference with the sponsor's rights, not freestanding rights held by every member of the family.
Yeah.
Can I come to the proportionality exercise in the last 40 minutes or so?
That's it. 5 points.
So this is your ground 3.
Ground 3.
Thank you.
Skeleton powers 39 to 53. Just on overview and standard of review, just to focus on 4 particular aspects. I'll take them in turn. 1, the weight to be given to immigration control and the presence or absence of settlement schemes. 2, the nature and quality of the family life found. 3, how
Sorry, take it a
2.
bit more slowly. Settlement schemes, which was 2.
2 was the nature and quality of the family life found. What's the nature of the interference, effectively? 3, how the best interests of the children feature in the analysis.
Yeah.
And 4, how the risk of death for one or more of the respondents should feature in the analysis.
Risk of death.
Yes. And I'm going to focus on those 4 areas, but there is an initial point, which is what the approach of this court should be to proportionality. And that's a subject which has recently exercised the Supreme Court in a case which may not be familiar to my lord and my lady, called Schwidler.
It's certainly familiar to me. So
Yes. My lord, sorry, I should have said we discovered over the short adjournment, I think the case you might have had in mind in relation to AB,
yeah,
at least it was one of mine, it was a little time back, but it was that Barnett case where
that's right.
there was an allegation of wrongdoing in relation to children.
The Nigerian family.
Exactly.
That's
and Vienna Convention
Thank you very much.
It was that one, I think.
Yes.
It's paragraph 11 of that one, if you need it. We can provide you with a copy.
Paragraph 11, wonderful.
But you referred then to AB and cited.
Schwidler, we were unusually upheld, I think, Sir James.
I thought, well, it was never in doubt.
Saved by Lord Legate, I think.
Saved by Lord Legate, who regarded this as his liver Susan Anderson moment. I was allowed to say that about Lord Legate.
Yeah.
But my lord, they were particularly interested in this question on which I know Lord Sales has delivered a lecture or two, about what the approach of the appellate court should be. I'm not going to reinvent the wheel, I'm getting lots of nodding, but the relevant paragraphs, the Schwidler is in 32, tab 32, page 648 if you want it. The relevant paragraphs are 142 onwards, including probably to the end of about 160. There's a whole section analysing what you do. And perhaps as ever, and wisely no doubt, with the Supreme Court, the door is left ajar to allow for individual circumstances to play, in particular future cases that might come along. But the basic message, if I can summarise, no doubt grossly oversimplistically, is that if a case, they don't get too obsessed with the distinction between facts and law or legislation or whatever. There's obviously a divide between a case which is just simply about, the application of an individual, of a legislative scheme to a particular individual. That's on that side of the line, apply the wrong approach and move on. And there may be cases where you're attacking the compatibility of legislation or an entire scheme, probably the paradigm example at the other end of the spectrum, and there are some more flexible bits in the middle. But the basic message, I respectfully submit, from Schwidler goes to the degree of significance or importance in relation to the court's reasoning. And if the case, because you could have said, well, Schwidler is just about Schwidler, they're not really challenging the Russia sanctions regulations, it's all about the application of the individual case, but they considered that it was an important case which would set the framework for how lower courts should go about thinking about these things in that statutory context, so their judgment was likely to be of real significance. And in those circumstances, the case for the appellate court doing more than simply acting as a court of quasi-review was stronger. And the short submission that we make in this case is it would at the very least be open to this court to conclude, particularly in the light of some of the complexities that you have now seen from the case law and the obvious significance of some of these issues, that you might feel that this is a case which falls on the, or closer to, the side of the line where you want to take at the very least, a more intensive look at proportionality for yourselves, rather than adopting the rather more stand-back approach of looking to see whether they've gone egregiously wrong. That's the submission I make. And I do so recognising that we've raised two very square points of principle in grounds 1 and 2, and when you get to proportionality, and can be said, well, that's a bit more facty, and I'll come to try and give you the paragraphs and say what we think the problems are, but there are at least some very significant issues in relation to how they've gone about doing this. In all the circumstances, looks like it actually collapsed in terms of the ultimate things that drove the decision making of the Upper Tribunal into the best interests of the children not to be exposed to the conditions in Gaza. There are obvious and broad logical ramifications for that, of very serious concern to the government for obvious reasons. And the question is, how does one approach those sorts of issues when you're doing a proportionality review in a case like this?
Well, I mean, if they were wrong, if the Upper Tribunal, because the Upper Tribunal remade the decision, So if the Upper Tribunal was wrong to take into account or in the way it took into account aspects of the
that would open the door anyway.
that's a question of law and the door is open.
Yeah.
If not, then you say, well, because of Schridler, which didn't completely answer the question I posed in my very short concurring judgment, but sort of did.
Yes, well, I tried to.
Well, it pretended to, I was going to say, but that's unfair. No, it tried to.
You're not allowed to say that.
No, of course not. And, but effectively it did, because it approved Lord Justice Singh's formulation of the approach. So, and then we should consider.
Yes, it didn't go with the three-way categorisation that Lord Justice Singh
No.
proposed deliberately at 149 to 160. So one needs to be a bit careful with that. But
Okay.
yeah.
I haven't studied it.
Well, my lord, I'm not going to, in the time available, be able to take you to it, but you have the paragraphs. You're very well aware of the issue.
Yeah.
Its degree of broader importance, as I say. Of course, if they're wrong at an earlier stage, the door is open anyway, and there we are. But it's that broader question about how you do proportionality in cases of this ilk, where you've got children, for example, exposed to awful conditions.
But then this case is a case where other cases are backed up behind it, isn't it?
There are other cases backed up behind it, but again, I don't really want to or need to, I respectfully submit, get sucked into precisely how many are directly on all fours or directly bound in, because these are broader questions of the logic of the reasoning. I mean, a war-torn zone on Earth is not an unusual feature. A zone on Earth where there is no war but the humanitarian catastrophe is enormous are not unusual. And these are the challenges of the times. These are the people who make it to the United Kingdom in significant numbers, and there has to be a judgment about what to do. So it's that broader logic which is as much of a concern as the directly stacked up cases.
I mean, that's why I asked you to point to the paragraphs.
Yes, my lord, yes. I just didn't want that to be taken as it were an indication from my lord that you only get there if you can prove that they've done something directly wrong on the facts or whatever.
But there's an intermediate position. I mean, they may have erred in the ways that you've encouraged us to find that they did in grounds 1 and 2, but even if we're against you on grounds 1 and 2, there are problems with the proportionality analysis which on your submission make it wrong on the conventional test.
Make it wrong on the conventional test, and then the only question, if you get to that stage and you're not with me on grounds 1 and 2, is whether you feel that Schridler opens the door to a more intrusive examination.
But we might not need to go there.
We might not need to go there. That's enough on Schridler unless you want more.
No.
I was going to start with the approach to the public interest in effective immigration control, and in particular the question what in reality drove the decision. The Upper Tribunal's proportionality analysis is at 141 to 184, paragraph numbers of its judgment, and immigration control is addressed at 147 to 156. It accepted as required by the Aguiarco case that, quote, considerable weight needed to be given or placed on the respondent's inability to meet the requirements of the immigration rules, but it refused beyond that to place any weight or any additional weight on the absence of any resettlement scheme in relation to Gazans or the Secretary of State's concerns as to the wider implications of imposing on the state a positive obligation to grant entry clearance in these circumstances. And it is important, we submit, to look at what really drove that proportionality conclusion in this case. If you do that, we submit, it is evident there is no effective limiting principle or basis for distinguishing this case from many others that will arise in the context of war zones or humanitarian disasters, such that the effect of the decision and its logic is and will be far-reaching. The reality is that even though the Upper Tribunal attached the weight they did to the fact that the respondents were outside the immigration rules, it required entry to be granted in this case because of two powerful factors which will be of very wide application. The first was the best interests of the children. And they gave very significant weight to that consideration. Upper Tribunal's decision 141 to 146 and 163. The second was the current circumstances, as they put it, of the respondents in Gaza. That's 164 to 166. The assessment of the Upper Tribunal contains reference to a series of other factors, as you see from the judgment, but none of them, is the submission on those, was really treated as being of any real significance or importance. So just to take them quickly, English language, paras 157 to 158, inability of R1 and R2 to speak English at a reasonable level weighed against them, but that added weight, as the tribunal concluded, is not significant. Financial independence, 159 to 162. The weight attached to that was relatively limited, even though one is talking about 5 people, even on just focusing on the facts of this case, coming, let alone the broader logic, coming to the UK, where the sponsor's net monthly salary was £3,700. The nature and quality of family life, 167 to 162, that was treated as a factor in the appellant's favour and given substantial weight. I'll address that further in a second. But when you come to look at why, it's really the risk of death again, C171. The Hamas issue, which it might be thought was a point which might have provided some basis of limitation of the breadth and logic of their reasoning, that's dealt with at 173 to 174, but it self-evidently doesn't provide a limiting principle in this case because they accepted the Secretary of State's submission that it doesn't take the appellant's case much further, attaching some weight to it on the speculative basis that it might impact on the respondent's access to aid. But the context is that the Upper Tribunal has already factored in that the respondents face an overall security and humanitarian situation which is extreme and life-threatening. So the Hamas issue doesn't provide any limiting principle or control. The sponsor's mental health is dealt with at 176. Again, not a consideration of great significance, as they put it, on the evidence, only some weight attached to that, 178. Financial independence, which was an issue, no impact as that was neutral, they concluded, 179. And ditto, no impact as regard the sponsor's positive contribution to the UK, 181 in their judgment. So the reality is that what lies at the heart of this assessment is the fact that the respondents, including their children, are in a war zone. That's what drove the decision, overturning, I may say, the FTT on that issue, that it would be a breach of Article 8 to grant entry to the UK.
I mean, is it not useful to look at Article 8(2) itself to frame the exercise they were doing? One often finds that these exercises are conducted without actually looking. There shall be no interference by a public authority with the exercise of 8(1), except such as in accordance with law, necessary in a democratic society in the interests of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. Now, is that what they should have been doing? Looking to see whether there had been an interference by a public authority with the exercise of the family life right found under Article 1, except in relation to those matters?
My lord, yes, that's what they should be doing.
Well, what I find amusing, because, as I say once again, I'm a private lawyer by training, is that there is never any mention in these cases of that formulation. So you have all sorts of factors, but they're never put under the headings of what they're talking about in the Article 8 itself.
My Lord, I suspect, in fairness to the
Yes.
courts and tribunals, august as they are, that have considered these matters, that there have been so many cases over the years in the immigration context that those basic concepts, that basic idea, that basic structure, into which one needs to put the idea of positive obligations on the state, there have been so many different formulations that have, as it were, taken that wording and moved, that courts tend to rely upon those and the factors they identify.
I mean, the problem for me is that those words all have meaning. And if you're applying an international treaty of this kind, made part of our own law by the Human Rights Act, one should one not, actually look at the words to see which of these factors could conceivably come within them or not.
Well, my Lord, yeah, sorry.
Because everything in the world does not actually fall within those words.
No, it doesn't. But the rights and freedoms of others, for example, has been taken as at least broad enough to cover the idea that a state has the right to control its borders, that a state has got to strike the right balances when it decides what positive obligations it is and it isn't under in the sphere of immigration control.
And maybe the economic well-being of the country.
And that also. I suspect if you went back to the very, very early commission and court jurisprudence, way back when it was twinkling in everyone's eye, I mean, you would find those things being built up gradually by the early case law. But it's well acknowledged.
What troubles me is we've got so far away from the language of Article 8 that these things have been lost in the mists of time. And it's why I asked you, where did the tribunal go wrong, the Upper Tribunal go wrong, and you've identified financial independence, English language, family life, risk of death, Hamas issue, etc., mental health, financial dependence, positive contribution to the UK, and the war zone. Do you say that any of those is not within Article 8.2?
Well, we don't make that submission. The submission I'm on at the moment is that the error, if you will, that I'm really trying to drive at under this first heading, it is the one that discounts the broader concerns. It goes to the concerns that a state can legitimately have about the consequences for immigration control, for public finances, and all the rest of it, of a particular group of people being admitted. But that is why it might be thought things like resettlement schemes exist, because they require the democratic imprimatur that is necessary in order to generate further additional funds for the groups that might be covered by a particular war zone or a particularly egregious humanitarian condition. So what I'm driving at under this principle is the error that says they as it were, did not pay sufficient or proper attention to the true significance of the concerns that the state has about maintaining effective and economic control over immigration. That's why I'm driving at no effective limiting principle. That's why I went to the Hamas issue, not in its own right, because in order to identify, I was seeking to identify the things that might in its other factors have provided a particular way of limiting the worry to this family. Well,
so you say they didn't pay sufficient or proper attention to the significance of the state's concerns to maintain effective economic and something else control over immigration.
Effective and economic control.
Effective and economic.
Well, with the economic consequences, yes.
Yeah, okay.
That's why I'm driving.
I've written that down. That is your submission.
That's the submission, and it goes to how broad the logic runs.
And you say that has, we can use the pejorative term floodgates, but you say that has a very significant effect on immigration control across.
And the true and proper weight that is to be accorded to that in the balancing exercise that is inherent in the imposition or not of the relevant positive obligation on the state to admit. If you're going to admit 3 people, that's one thing, or 6 people, that's one thing. If the logic of admitting the 6 is that you then admit 4,000, that's a very different thing. And what the tribunal did was to say, no, this is all over-exaggerated, and don't worry about the fact there isn't a settlement scheme and all of that. But in truth, when you look at their reasoning comes down to best interests of the children in a war zone.
So I'm sorry to bang on about this, but this is the reason why I wanted a bit of extra time for this case. You say it's different to admit 3 than to admit 4,000. That is because of the words of Article 8.2 that say what is necessary in a democratic society in the interests of national security, public safety, or more particularly here, the economic well-being of the country, for the protection of health or morals, or the protection of the rights and freedoms of others. So that actually gives the license for the tribunal to consider, in undertaking the balancing exercise, the further repercussions, the more general repercussions of deciding where the balance lies.
Yes, and we say they need to do that fairly and accurately so as not to underestimate the extent of the concern which the state legitimately has.
Because many people are affected by the same terrible conditions.
Yes.
We won't underestimate in any way the terrible conditions in Gaza as of now.
Of course, these are ghastly cases because the situation in Gaza is ghastly.
But you say there are many other places where the situation is probably not as ghastly.
Syria, any war zone,
terrible
appalling conditions in African countries due to famine. And so the concerns that we respectfully rely upon are encapsulated, but it's pretty self-evident anyway in the statement from Mr. Ramsbottom. Don't invite you to turn it up. It's in the supplemental bundle at tab 13, page 105.
Yes.
But they are essentially those points. They might be thought to be self-evident in any event. There are many conflict zones and humanitarian disasters in the world. Many of the people suffering in those conditions are children. And the people who suffer worst are children. There may be many cases where there's a family member in the UK. It's right and valid for the tribunal to rely upon those consequences as properly indicating the weight of the public concerns, the door to which is opened, as my Lord has rightly reminded us, in Article 8.2, because they have the logic to lead to significant numbers of people coming in and then having to be supported in the United Kingdom with all the difficulties that we know are current and controversial. This is not double counting. The fact that the person is not within the emigration rules does not withdraw the significance of that broader impact.
But you're not disentitled, are you? I mean, I'm asking, from taking into account the terrible position of the children once they are a member of the family concerned. Am I right or wrong?
No, you can take that.
You can take that into account. It's how much weight you give it.
How much weight you give it, and for this purpose, it is. It has to be taken into account in the right way, perhaps, is the codicil to that. It's got to be taken into account through the rights holder.
Well, there's a further, perhaps a slightly narrower point, which it might be thought the Upper Tribunal has ignored, which is that its decision is binding on judges of the First Tier Tribunal. So if you take the case of Al Hassan, which you showed us, that was relied on by the First Tier Tribunal in this case in order to decide that there was family life in this case.
Yes.
And who knows how this decision of the Upper Tribunal will be interpreted by First Tier Tribunal judges, but it might well be interpreted as saying, well.
Yes, fine. My lady, I accept that. My lady, I was on the point about double counting, because you'll remember that they got a bit exercised about double counting at paragraph 93, and my short answer in relation to that is that double counting doesn't really get one anywhere, and it's not, in fairness, accurate to discount this as, in effect, double counting. That they're outside the immigration rules, but that does nothing to diminish or lessen the nature of the state's legitimate concern about the breadth of the logic of letting people in on the basis that they're children in a war zone. And nor does any of the argumentation that appears to have occurred below about resettlement schemes or not resettlement schemes touch the point either. Sometimes the government, no doubt with parliamentary stamps when appropriate, will put in place, it will always be appropriate because they'll almost always be part of the immigration rules, I think, but will put in place a resettlement scheme of the kind that you saw in relation to Ukraine, which was the form they tried to use. But the significance of that is it's gone through the democratic processes. Everyone's decided that because of the particular setup in the country concerned, special rules need to be made. But my broader point is it doesn't matter whether there's such a scheme or there isn't a scheme. If there is a scheme, then that scheme operates. If there isn't, you've got the concern in yours. And it hasn't had the democratic exception made to it. But it's the breadth of the concern which legitimately bases the extent of the state's interest in the protection of proper and effective immigration control that matters. And that's why I went through the exercise of seeing what really drove the decision. That was the purpose of that analysis, to see whether it really was, in truth, children in a war zone, and it was.
But you can take into account children in a war zone.
You can take into account the fact that they are there. You've got to do it for the purpose.
And perhaps more particularly the worry that it causes the sponsor.
Exactly. That's the link back in. That's the link back in, and then the question is whether or not that is sufficient. But you take it into account for that purpose, but bear in mind that the first point is about the other side of the scales. This is about the state's legitimate interest, part of the proportionality balance, in effective control of immigration. And that's a legitimate thing for them to balance. That's essentially what balance is on the other side of the scales in these cases.
And there are authorities that say that?
That say,
the state's legitimate interest in controlling immigration.
my lord, yes.
I mean, I think I've probably...
Many.
Many.
Many, I'm afraid.
Yeah.
We'll see if we can identify a really good one for you, but many is the answer to that. Well, I was going to turn secondly to the approach to the nature and quality of family life. And again, we've to some extent touched on this already.
But you haven't pointed out in the context of the state's legitimate interest in controlling immigration and the decision being driven by the fact that there were children in a war zone, any factor taken into account by the Upper Tribunal that ought not to have been considered relevant. I mean, any paragraphs on those subjects that are simply wrong. I mean, I understand the balance point. You say too great weight. You say what drove the decision. But at the moment, I'm just trying to identify...
Well, the core errors, if you want those.
Yes.
I mean, lots of the paragraphs I gave you earlier were for the purpose of trying to identify and isolate what actually drove it. Children in the war zone.
Yeah, get that.
You start with that. And the errors that then occur are not to afford a proper respect to and weight to the state's interest in immigration control, by which I mean broader impacts. If it's just children in war zones, how big is the state's concern? And we say very big, and that was not a conclusion which the Upper Tribunal reached, on the contrary. What they did instead was to say, well, we attach great weight to immigration control generally, but then they did a set of reasoning which effectively discounted the significance of there being no resettlement scheme and the broader issues.
But you may, I mean, I do get that, Sir James, but it's notoriously difficult to balance. I mean, you're going to mention life itself, but it's notoriously difficult to balance somebody's life against the economic interests of the state. And, you know, because different people may take, there may be very callous people who say none of this matters at all, but assuming that we're all very human and we all care about others very deeply, how is that balance achieved?
Well,
Because this tribunal took very seriously the risks to which these appellants were facing. And you know, let's assume in the favour of the tribunal's decision that their lives are at risk. How do you balance that?
Well, my lord, you balance it. I'm afraid that the answer to that philosophically, as the Supreme Court has regularly recognised, is that what you're doing when you're balancing these convention rights, when you get to the second paragraph, is to balance incommensurate interests, as they've regularly put it, which means interests that don't naturally balance against each other, but you have to do the exercise in the way that the Strasbourg cases indicate, and you have therefore to be rigorous in your approach. You have to say, well, what is the state's interest in immigration control if this goes ahead? How weighty is that? If the logic of it is that anyone, however ghastly it may be, who is subjected as a child to a risk to life and has a relative in the United Kingdom can come in, then the door is wide open. That's extremely significant.
The key point is that the United Kingdom is not responsible for Article 2 and Article 3 risks
In other states.
in other states, because precisely for the jurisdictional reasons that you were explaining earlier.
So is your submission then effectively that in circumstances where there is no scheme and everything is outside the rules, and there are likely to be economic consequences of allowing everyone in, that the balance will always favour the government?
Well, the balance will very often favour the government. It will. I can't say always, because one can think of perhaps some extreme cases in which the impact on the individual here is of particular significance or severity. But what I do say is that if you simply say there's an Article 8 right of whatever description, however tenuous, because they've got an uncle in the United Kingdom, and what then happens is, in effect, an analysis which centrally focuses on and is driven by the risks of Article 3 or Article 2 type ill treatment in the foreign state, then that is, in effect, to impose a responsibility on the United Kingdom, which the Convention does not. Because, as my lady identified, we are not responsible for the treatment, however ghastly, in other states. I was going to go, my lady, I was going to go to the approach to the nature and quality of family life in the few minutes remaining, maybe 15 or so minutes tomorrow morning to finish this. But the second of the topics is approach to the nature and quality of family life. Our skeleton 49 to 53, Upper Tribunal's judgment 167 to 172. We do submit particular family life in this case was a relatively tenuous or peripheral form of family life. We do not accept that if family life is demonstrated, all family life is the same. Just as you need to consider the extent of the state's interest to the extent that it's engaged in effective immigration control, so you also are entitled to take into account the nature of the interference with the family life on the particular facts.
And 169 is important in this context. Perhaps I'm anticipating what you're going to say, but no family life before the conflict beginning in October 2023.
No, none at all.
And no prior intention of the appellants to be reunited with the sponsor in the United Kingdom or indeed anywhere else outside of Gaza.
Well, lady, yes.
So that's what we're talking about.
Yeah. I've given you the facts and circumstances relating to that family life. I did under the topic of family life earlier. I'm not going to go back to that, but my submission on the back of all of those facts is that the family life here would be remote or tenuous at best, even if it falls within the concept. It was only formed, as the FTT found in October 23. There'd been no cohabitation, which is normally what's required for Article 8.1 family life. There was no dependency in the strict sense that we've identified. It was formed when there was no right for the family to unify in the United Kingdom under the immigration rules. And the existence of family life between the sponsor and everyone other than the brother, i.e. the grown-up father, was by extension. See the FTT decision at paragraph 26. And 169, which my lady has drawn attention to, makes reference to the recent point, to the no cohabitation point, and treats those as points which, had they been present, would have increased the weight to be given, but does not class the family life as found as peripheral or tenuous or outside the core paradigms with which Article 8 is concerned, and doesn't therefore deal with the weight.
So do you say the end of 171 and the whole of 172 is actually wrong?
My lord, we do. We just say that is not a conclusion that could properly have been reached on the facts here.
No, I would like to have a comprehensive submission tomorrow as to precisely which parts of this exercise you say is wrong. I understand it will be wrong as a matter of weight, because you accept that if there is a family life, then obviously that comes into the balance. But the formulation in 172,
Yeah.
that it's just because it's a less strong family life than it could be, doesn't mean little weight is to be attributed, is precisely the reverse, I think, of what you're submitting.
My lord, yes. We say that the errors were twofold. One of them was that they did not properly recognise, in principle, that the extent of family life is important. The nature of the family life on the particular facts is important. And secondly, had they focused correctly on that question, they could not have concluded anything other than that it was of the most extremely tenuous kind, for all the reasons that we've gone through. Instead of which, they just say, oh, well, it's not quite as weighty as it might have been, but it's still pretty weighty.
Yeah.
That's the concern with this part. And I'm very conscious that you are wishing to rise at 4:15. I've probably got 2 or 3 more pages, which will probably take me 15 or 20 minutes in the morning, no more.
Okay. Mr. Hussain, are you happy with that? Or not happy, but content? You weren't expecting a whole day.
With the sort of broad agreement was that the James would be the day. I'm not going to quibble about 10 or 15 minutes there, but
you'll get it.
I'll need my time. There's a lot of material.
You'll get a bit longer than you were expecting. Good. Okay. Well, we'll resume at 10:30 tomorrow. Thank you.
All rise, please.